Good afternoon. Thank you for joining this webinar. My name is Bob Donovan. I am an attorney and am well-versed in issues relevant to the industry, including tip pooling. Today, we will be discussing the current landscape of tip pooling laws, risks, and options for addressing them, followed, as Stephanie pointed out, by a question and answer period. So on the next slide, we list here laws to consider in Washington. Basically, you have federal law, Seattle, if you have employees in the city, and there's no Washington law regarding tip pooling, but there is one for service charges, as we will discuss a bit later. On the next slide, let's discuss federal tip pooling laws. Per Federal Department of Labor regulations, tips are the employee's property, and the employer cannot take them except to implement a valid tip pool. So these regulations limit who can be in a mandatory tip pool and when. First, only those employees who are customarily and regularly tipped can be in a mandatory tip pool. Now, there's a number of factors that courts and the Department of Labor consider in determining who meets that test. Most important factors typically are the employee's duties, where in the restaurant they're performed, and most importantly, whether the employee regularly engages in direct customer service. Second, those customarily and regularly tipped employees can only be in the tip pool when they are performing tipped functions. So, for example, a busser is a position that Department of Labor has recognized is good for a mandatory tip pool. But let's say your busser spends an hour in the dish pit before the restaurant opens or after it closes. Many courts and the Department of Labor take the position that in that instance, for those periods of time, the busser is more akin to a dishwasher, and they therefore typically rule that for those periods of time, they should not be in the tip pool, even though they're, maybe in your POSI system, they clocked in as a busser. Now, a general guide regarding who can be in a mandatory tip pool is you can include only the front of the house. You need to exclude the back of the house and management. And when we talk about management, that's a broad term under this law in terms of, for example, do they have the ability to impact the terms and conditions of other employees' work? If so, even if they're an hourly supervisor, if they are able, for example, to schedule employees, to cut them early after the rush, to discipline them, things of that nature, they are more likely to be deemed managers. In terms of the back of the house, there can be exceptions to this general guide. For example, the expediter position is typically viewed as a back of the house position. They're not on the floor. They're not engaging with customers. They are in the window checking the quality of the food. So they should be excluded from the tip pool. But let's say your expediter also runs food out to the dining room, to the tables, as part of their shift. In that sense, if they're an expediter / food runner, then they're okay for the tip pool. But let's change it again slightly. Let's say on Mondays, they're in the window only as an expediter. They're not running food. Tuesdays, they're running food. Mondays, when they're only an expediter, they shouldn't be in the tip pool. Tuesdays, when they're running food, they can be. So it's very nuanced is the point. On this next slide, let's discuss, does this federal law apply in Washington? Currently, this is a gray area which presents risk. As you might know, in 2012, we filed a lawsuit challenging the application of these federal laws in instances when the employer does not take a tip credit against the federal minimum wage. The Oregon District Court in that case ruled in favor of the industry that federal law doesn't apply in such instances. In February of this year, the Ninth Circuit reversed that decision industry, therefore, requested reconsideration by the three-judge panel or en banc review by the entire court. And on September 6th, the Ninth Circuit denied that request. So the current status is the WRA and its co-plaintiffs have until December 5th to request Supreme Court review. There's no guarantee that such review will be sought in this case. There's a number of factors that need to be considered and weighed. In the meantime, just note that when our case was reviewed by the Ninth Circuit, another similar case out of Las Vegas against the Wynn Las Vegas was consolidated with our case. So they also received that negative ruling by the Ninth Circuit. In August, they petitioned the Supreme Court to review the ruling for their case. It doesn't necessarily impact our case, but just note that they did seek Supreme Court review. On the next slide, let's talk about from now until December 5th, what the landscape looks like. The Federal Department of Labor will not likely challenge employers in the Ninth Circuit regarding their tip pools. The Ninth Circuit ruling in our case technically does not take effect until after December 5th if by then the plaintiffs have not filed a petition for Supreme Court review. Now, understand though, in the meantime, plaintiffs can still file a lawsuit under this federal law challenging a local practice, for example. If that happens and a lawsuit is filed locally under this law, that local court may stay that lawsuit pending further action, for example, Supreme Court review in the Wynn case. If that lawsuit is filed locally, you have other arguments that you can make. For example, in the Fourth Circuit, which oversees Maryland, Virginia, West Virginia, a couple other states, that court ruled that even if these regulations are valid, the only remedy under this federal law is to pay unpaid minimum wage or overtime. It doesn't allow for reimbursement of tips to employees paid at least federal minimum wage. Now, so that's a great ruling for the industry, but a local court does not have to follow that. It does not have precedential value here. It just has persuasive effect. So for now, the risk is that a local plaintiff files a lawsuit in a local court. That court does not stay the lawsuit. It allows it to continue. It follows the Ninth Circuit ruling. And your other arguments, like the one on this is not an appropriate remedy under federal law, might fail. One of the questions we got before coming onto the webinar was, what's the penalty? Under federal law, the penalty presumably would be the repayment of tips, either of all the tips contributed to the tip pool or only those contributed to the back of the house, plus an additional amount of equal value. So let's say, for example, it's $50,000. It would be another equal amount of $50,000 in that example, plus the plaintiff's attorney's fees. So let's go on to the next slide and review options at this time. If you have a mandatory tip pool that might violate federal law, your options include, number one, maintaining the status quo while awaiting possible action at the Supreme Court level, or changing the tip pool to a mandatory one that complies with federal law, or converting to a different model, such as a voluntary tip pool, service charge, hybrid tip pool, service charge model, a system for guests to tip the back of the house, or some other model, for example, no tipping. So let's go to the next slide and discuss in greater detail this first option. Waiting for Supreme Court review before making changes to your tip pool is the most risky option. And frankly, it's not the course I would recommend at this time. The Supreme Court accepts only a small fraction of requests to review circuit court opinions. There's no set deadline for the court to rule on such a petition. Even if the Supreme Court accepts Wynn's petition or the WRA's if it's filed, there's no guarantee they will reverse the Ninth Circuit ruling just because they agreed to hear the issue. So the odds are at this point, unfortunately, that the Ninth Circuit ruling will stand. And so damages will continue to add up in the meantime if you have a tip pool model that's violating these laws. And again, even if a lawsuit is filed and you decide to try to make these other arguments, there's no guarantee those other arguments will win in a lawsuit filed locally. So again, my recommendation is to assume the Ninth Circuit ruling will stand and make necessary adjustments. On the next slide, let's just briefly talk about the Seattle landscape for those of you who do business here in Seattle. The risk increases in Seattle. First, businesses likely would not be able to use other arguments available under federal law. For example, the one regarding repayment of tips is not a remedy. Let's go through it a little bit. First, the Seattle minimum wage. Office of Labor Standards issued frequently asked questions concerning the Seattle minimum wage. Those FAQs used to say that anyone in the chain of service can be in a mandatory tip pool, including the back of the house, though it's more nuanced, again, for shift supervisors. After the Ninth Circuit's February ruling, OLS changed those FAQs to no longer follow the chain of service model and instead explains that Ninth Circuit ruling. So it's likely that Office of Labor Standards would apply the federal rules with respect to the Seattle minimum wage, which would put your tip credit under the Seattle minimum wage at risk if you have a tip pool that violates that law. And again, I would just point out that federal law would trump the city law if the federal law is more favorable to the employee. So at this point, I would assume that the city would follow the Ninth Circuit's ruling with respect to the minimum wage. On the next slide, let's talk about the Seattle Wage Theft Ordinance. This law prohibits an employer from taking an employee's tips unlawfully. So presumably, a remedy under this law would be repayment of those tips if they were taken unlawfully, for example, by way of an invalid tip pool that includes the back of the house. Also, just a reminder that the Seattle wage theft law requires employers to provide a written notice of their tip pooling policy. As of April 1, 2016, that notice regarding the tip pool, and by the way, regarding a whole bunch of other things, was supposed to go to current employees by April 1, 2016. Thereafter, at the time of hire for new employees, and any time the policy changes. So if you change your tip pool model, you must provide written notice to your employees of that change. Remedies under both of these Seattle laws is a 3-year look back to file the claim, back pay plus up to 2 times more. Under the federal law, it's up to 1 times more. Under the city, employees get even more money. Attorney's fees, obviously your own attorney's fees for defending the law, and then also the employee's attorney's fees if they succeed in their claim. And then those laws provide for other remedies, smaller remedies, penalties to the city, penalties to the employees. So these laws do have teeth, and they increase the risk of delaying changing your tip pool changes in Seattle. Let's go on to the next slide and talk a little bit more about options at this time. If you nonetheless decide to keep the status quo until the Supreme Court rules on the Wynn petition, or in our case, if we file one, I urge you to come up with a backup model and be prepared to roll it out on short notice, such as if or when the Supreme Court denies the petition. If you change your model, understand there are still risks and issues to consider. For example, if you want to convert to a mandatory tip pool that only includes customarily and regularly tipped employees, complying with that federal law can be nuanced. I gave an example of, bussers who also spend blocks of time in the dish pit, expediters who are also food runners. Another example that sometimes comes up is the service bartender. In some cases across the country, service bartenders have been challenged, and courts have ruled that, for example, if the service bartender is making the drinks for the dining room behind a wall, sort of on the back line, where they're not visible to customers and they're not engaging with customers, then they shouldn't be in the tip pool. They're more akin to a cook. But if the service bartender is behind the bar, is talking it up with the bar patrons, but is only serving the dining room, then that's okay for inclusion in the tip pool. So they're very nuanced, and you just have to make sure that you're doing it right. For the voluntary tip pool option, understand that it must truly be voluntary. These are frequently challenged as not being voluntary in practice, even if writings in the handbook or in standalone policies say that they are voluntary. For example, it would be a major red flag if you convert to a voluntary model and everyone continues tipping out the back of the house the same amount every night as they did before the change. If your voluntary tip pool model is challenged, it will be your burden to establish that it's voluntary. And just note, though, that there are different voluntary tip pool models to consider, different ways to communicate them, and to show and steps to take to show that they are voluntary. So keep that in mind. Stephanie, I'm getting some reverberation. Did anything happen with the line? Can you still hear me okay?
I can hear you okay, Bob, but yeah, we have suddenly gotten some feedback. Let me double check to make sure everyone except for you is muted.
Okay.
Okay, Bob, I think that should have fixed it now. We had some people join after the fact, and we were getting reverberation off their phone.
Okay, great. So then, service charges. There's several issues to consider with respect to service charges. First is the state service charge disclosure law, which requires disclosure to guests of what percentage of the service charge is going to employees serving the customer. In practice, it's easy to run afoul of this disclosure law. For example, one way that some run afoul of it is to be over-inclusive, to say, for example, 100% of service charges go to our employees, but if 50% of them are going to the back of the house, lawsuits have been filed saying, hey, you should have disclosed that only 50% was going to the front of the house, for example. So there's been a number of lawsuits filed under this service charge disclosure law. Typically, they're filed as a class action, and obviously they're pretty expensive to defend against. They haven't resulted in much case law because typically they settle. So understand that's a big issue to make sure you're complying with. Also, service charges impact the overtime pay rate. Unlike tips, service charges paid to employees are deemed a wage, so they go towards the overtime rate of pay. They also impact your FICA tip credit. The FICA tip credit does not apply to service charges like it does to tips. So those are just some different issues to consider if you are considering going to a service charge model. On this next slide, let's discuss a hybrid model and systems for guests to tip out the back of the house. First, the hybrid tip pool service charge model. The idea here is that you apply only a very small service charge, for example, 2%. The guests presumably would still be tipping out because it's such a low service charge. The tips that are left would go directly to the front of the house employees, and the service charges would go to the back of the house to offset them being taken out of the tip pool. Now, for this kind of a model, you still need to ensure the tip pool is appropriate, and you still need to comply with the service charge disclosure law, but it might be less of a culture shock for your staff and for your guests, and it would presumably minimize the impact on FICA and overtime. So that's a model to consider. Systems for the guest to tip out the back of the house. A model here would be, for example, adding a tip line on the guest check. One tip line would be for the front of the house, one would be for the kitchen. If guests leave amounts on the tip line for the back of the house, in my mind, they have become customarily and regularly tipped, since the customer is saying, I want them to receive some tips. Although, like anything else, it's still subject to challenge. There's no, silver bullet to prevent lawsuits. But I kind of like that model. Note, though, that your POSI provider may not have the capability to add another line in this manner to the guest check. So if it's a model that you're considering, I recommend first checking to see if it can be done administratively. Also, I recommend, if you go with a model like this, that you do not commingle the tips between the front of the house and the back of the house. So, for example, the amounts left by customers on the front of the house line should only go to the front of the house, and the amounts left on the back of the house line should only go to the back of the house. You don't want, in this kind of a model, the customer is saying where they want their tips to go, so you should be honoring that. Now, on this next slide, let's talk about the bottom line here. First, decide how you will proceed concerning federal law while awaiting the potential for Supreme Court review. Second, as I said, I recommend assuming the Ninth Circuit ruling will stand and making adjustments accordingly. If the Supreme Court does actually grant review and does overturn the Ninth Circuit ruling in the future, you can always change back to your current model. Third, don't go it alone. I highly recommend that you work with a trusted advisor to truly understand these options and best practices within each model. For purposes of this call, we are at about a 3,000-foot view. The devil is in the details when it comes to these issues. And presumably, if you're making a change, it's to ensure compliance. You're getting it right as you cross the finish line. On the next slide, let me just present one last suggestion. I recommend considering having your employees sign an arbitration agreement with a class actor. These types of agreements are not a substitute for legal compliance, and they do not shield you from all legal actions. So, for example, if you go in this direction, don't just assume, okay, now I don't have to worry about legal compliance. For example, Department of Labor or Office of Labor Standards can still come in, do an investigation. If they find violations, they can take enforcement action for back pay and damages for all of your employees. And by the way, individual employees can still bring claims in arbitration. These arbitration agreements also have some downsides. For example, morale issues. They cannot be unconscionable, so typically that means you need to pay 100% of the arbitrator's fees. So they're not right for everyone, but employment laws are complicated. Even if you are in compliance with employment laws, a class action lawsuit alleging otherwise can still be filed and is expensive to defend against. And you can take steps to mitigate the potential downsides to these types of agreements. So again, knowledge is power. If you want to consider an arbitration agreement with a class action waiver, I recommend you don't go it alone. Work with an attorney to understand the pros and cons and how to implement these kinds of agreements. This last slide now opens it up to questions and provides my contact information. If you're not able to ask a question now, then you have my contact information for later. When we open this up to questions, go ahead, Stephanie, sorry.
Oh, no, go ahead. That's first. I was going to say that you've had 3 questions in the chat box so far, so I can read those off to you, and we can address those first, and then we can take the questions over the phone if that works.
Sure, that's fine. When presenting the questions over the phone, I would just ask, don't identify yourself since this is being recorded, but Stephanie, that's just my thought.
Great.
Okay.
Let's unmute you all.
Unmuted.
Okay, everyone is unmuted at this time, so if you're starting to get any feedback, please let me know or self-mute. I'm going to read the first question, and it was, does this apply to all tipped employees of any size establishment?
I'm sorry, I'm getting a lot of noise.
Muted.
Hi, Bob. Sorry about that. I had to remute everyone, so I read that first question. Go ahead and answer it. I can read it to you again. It says, does this apply to all tipped employees of any size establishment?
Yeah, that's a great question. Under federal law, these rules apply if you have at least $500,000 in annual revenue and 2 employees for the most part. So for most folks on the call, I would assume that it applies to you, and obviously Seattle law applies to even more employers, and it would apply to all employees of the establishment. So it gets to even the small employers.
Okay. So next question is, can an employee manual make a suggested tipping percentage for servers to offer kitchen staff based entirely on a voluntary basis if the staff member signs with the signature, if they sign the employee handbook? Meaning if they choose not to tip, that's up to them. But in the revised handbook, could we include a section weighing the pros and cons of sharing tips with kitchen staff and offer our suggested percentage?
So, yes, the manual can make suggested percentages. I would recommend against that, though, because the risk that I would see with that is if everyone's tipping out that suggested amount, then again you're at risk of a claim that it wasn't really voluntary, that even though the handbook says it's voluntary, in fact, everyone's tipping out that suggested amount because we're told verbally that, yeah, it's voluntary. You can either do it or you can go down the street and get a different job, for example, right? And so I would recommend against a suggested amount. Okay.
Okay. Let me go down to the next question, which was, is there currently a stay of the Ninth Circuit decision, or is the stay tied to the December 5th deadline?
Yes to both. There is currently a stay of the Ninth Circuit decision. In our case, it's tied to our December 5th deadline. I don't believe WIN's filing for Supreme Court review technically impacts Circuit's ability to send their ruling down to our court in Oregon to have that ruling stand. So I hope that and I hope that answers that question.
Okay, I've got one more here. It says, we use GratiTrack to track gratuity. When the servers are checking out, it gives a suggested amount for tipping out to support staff and back-of-the-house staff. The tipped employee does have the ability to change these amounts. Would that be okay for a voluntary tip pool?
Yeah, again, the devil's really in the details. If it, it would depend on how it's giving that suggested amount. It would depend on if employees are actually changing that amount or they never do. For example, if it's pre-populated with that amount and employees are just skipping over it and just allowing that amount to stand and not physically going in and altering it, then I see greater risk there. If, for example, there are it's just an amount as a percentage that's not pre-populated, and the employees have to go in and either put a zero or some other amount, and there's great variability, and employees are actually using a zero, for example, and not including any, then I think you're okay there. So it really depends on how it's set up and how employees are reacting to it.
Okay. We're seeing more as we're going along here. Here's another question. What about counter service restaurants? Can tips be pooled by all employees with a written agreement?
Yeah, it really depends on what employees we're talking about. Like, if the counter service restaurant has folks in the back of the house still, then no. The written agreement would be deemed a mandatory tip pool, and the folks in the back of the house, even though it's a counter service restaurant, would be deemed part of the mandatory tip pool in violation of that law. If, for example, it's an ice cream parlor or a coffee shop and the only employees are 3 people behind the counter taking orders and scooping the ice cream or handing over the donuts, and there's no one in the back of the house, then sure, those 3 employees in that instance would be eligible for the tip pool.
Okay, moving on, we've got another. If we're going to a hybrid model, would the small service charge, 2% was mentioned, need to be legally disclosed to the customer?
Yeah, absolutely. If it's a service charge, you have to meet the Washington State Service Charge Disclosure Law. You got to disclose it. And by the way, if you're in CTAC, I think you have to pay attention to that CTAC law. It might have some additional requirements. So yes, no matter what the percentage, if it's a service charge, it has to be disclosed to the customer and meet the service charge disclosure law's requirements.
Okay. Next question. Why are waitresses specifically protected from tip credits in Washington State, where 95% of the U.S. allows tip credit?
Yeah, great question. I wish I knew. I don't know. I don't know the history behind Washington's decision to not allow for a tip credit.
Okay.
So, sorry, I can't be more helpful.
No, I mean, that's honest. There are a lot of times that we have that same dilemma here at the Restaurant Association. So moving on to the next question. Go ahead.
Well, I was just going to say, I mean, it's not unique to Washington, as you know. I mean, you have Oregon, you have some other states, Alaska, where there's no tip credit. You have other states where the state gets involved in, for example, requiring that tip pools can only be voluntary and getting into the weeds on what that means under that state law, for example, Minnesota. So other states And then like New York and Massachusetts, they both have laws dealing with service charges that are even more restrictive than Washington's disclosure law. So different states handle these issues differently, which makes it really tough for operators who operate nationally.
Gotcha. Okay, so the next question is, we have a food truck and tips are split evenly based on hours worked. There are order takers and cooks and prep cooks. Are we in compliance with the law, or do only the employees in contact with guests qualify as tipped employees?
So, yeah, again, I wish these rules were just clear cut and the answer were yes and no. But it really depends on the details. Are the cooks and prep cooks in the food truck doing their work in view of the people who are ordering the food? Are they saying hi to the customers? Are they, engaging in any flair, for example, or are they sufficiently in a position where you can argue that they meet all the the factors for inclusion in a tip pool? I don't know. But it's going to depend on that kind of a in-depth analysis of the position to be able to give you a better handle on if you're in compliance. But typically the safe answer is only those with contact with the guest qualify as tipped employees. That's the safe approach. But if you want to get a more detailed analysis, then you gotta have someone take a closer look at your specifics.
Okay. Looks like we got a question, John, here about Initiative 1143, and we will be happy to talk to you about that offline. Bob's time today is specifically towards tip pools. And then another question, if there is truly a voluntary back-of-the-house tipping pool, can a manager or owner then take that amount of tips and distribute it to the back-of-the-house employees as they see fit based on hours and their job assignment, et cetera?
Yes. That's, one of the challenges with a voluntary tip pool system is you still need to be, quote unquote, following the money for purposes of reporting declared tips to the IRS at the end of every year. And if it's truly a voluntary system in the sense that, sort of a quote unquote pure voluntary model where management doesn't get involved at all, whatever a server does with, or a bartender does with the tips that they collect off their tables or across the bar at the end of the night is totally up to them. Then you run into the potential for abuse of underreporting of those tips. And if it's substantial underreporting, then you run the risk of the IRS coming after you and saying you owe payroll taxes under the amounts that were underdeclared. And so a lot of employers like to guard against that by still saying, okay, look, it's a voluntary model, but we have to set up some safeguards to address that abuse, to make sure that the back-of-the-house employees are declaring the tips that they receive through this voluntary model, and that the front-of-the-house employees declaring their tips are not abusing this and vastly underreporting their tips. So a lot of times, management still does look for ways to get involved for that very valid reason. And in the process of getting involved, setting up a system for distributing it to the back-of-the-house employees. And I think all of that is legitimate and valid, but you have to be careful about how you're getting involved to make sure that it doesn't look like you're getting involved so that you can put pressure on those who don't contribute on a given night. So I know that's kind of a long answer, but I wanted to touch on the importance of still being able to follow the tips for declaration purposes.
Okay. Looks like we have another question. Can an employer use a service charge to meet part of the new Seattle minimum wage, which I believe ties in because we've talked about using service charges in the place of tip pooling practices.
Yeah, boy, it's actually been a little while since I've looked at that, but my recollection is that the recommendation on that is yes, you can, but again, Seattle says you've got to comply with the Washington State Service Charge Disclosure Law as well. So number one, you got to do that. Number two, it's recommended that you only use it for up to the delta between state minimum wage and Seattle minimum wage. So in other words, you're not using the service charges to apply towards the Washington state minimum wage as well.
Okay, moving on to the first question from one of our other people on the line. In a small restaurant, we have a need for employees who perform dual roles. For example, our general manager will perform management duties for 3 or 4 hours per day, and then they will be performing serving duties for 4 or 5-hour shifts and take the tips from the tables that they served at that time. Are we still in compliance with the law?
You know, so the GM is performing management duties for 3 to 4 hours, okay, and then they perform serving duties and take the tips from the tables that they served. Theoretically, you know, it's okay, in my opinion, for a manager in that instance to keep the tips that they received off of their own tables. But if, for example, your policy is that servers contribute a portion of their tips to a tip pool, you should be contributing as well. If your policy is everyone contributes their tips and then the tips are redistributed back to everyone, including the servers, then I would say give your tips to that model, but do not take any of them being redistributed. In other words, give them up, because you don't want to be seen as having anyone giving any of their tips to you. And I will just point out, though, that even though that's my opinion on it, I don't know how a local court would look at it. I know Office of Labor Standards, when I've spoken with them about it, they didn't love the model. The example I gave was a bar owner who not only owns the bar, but also is a bartender a few nights a week. And can they keep the tips that they receive across the bar? And Office of Labor Standards looked at that really negatively, feeling like, no, they're the owner. You know, they're making more money than the other bartenders. All those tips should go to the bartenders, which obviously they don't understand, that not all bar owners are making a ton of money here. So, you know, that's my opinion on it. I would say go with caution, because I don't know if a court or OLS would agree with me. Okay. But that's how I interpret at least the federal law.
The next question we had is kind of in the same vein, Bob. It says, in an open kitchen, if the cooks engage the guests on a regular basis, will they qualify for a tip pool?
You know, there's the whole issue of, you know, some courts in the country have said yes. If the cooks are, or for example, the service bartender is, you know, engaging in flair, is engaging with the guests. You know, you see it sometimes at sushi bars where the sushi chef is actually engaging with the with the guests while making the sushi for their dish. It's a risky proposition, though, right? Because the fundamental issue that the courts will look at first is degree of customer interaction. And if they're engaging in customer interaction regularly, then your chances go up. But if it's an open kitchen where the guests can watch, but the kitchen is pretty far away, they're not, maybe they're saying hi to someone as they walk past the kitchen to go to the restroom, but it's not an integral part of their job. Then I would just recommend looking at that narrowly. So again, the devil's in the details. What's the interaction? What's the value added that interaction provides to the guests in terms of service and their experience that evening? So I would look at it closely.
Okay. And this looks to be the last question that we have typed in for now. What are the risks of a voluntary tip pool run completely by the wait staff with no input from the owners?
The only risk there is the potential for underreporting of tips and being audited by the IRS on that point and having to pay back IRS penalties for payroll that should have been applied to that, payroll taxes that should have been applied to that. So you just have to watch for that abuse. One question that I received, again, before the webinar started that was just sent in, I think, to WRA by email was, what is a tip pool and what is a tip share, and is there a distinction? For example, hey, what if mine's a tip share? Can I do it? Bottom line here is don't get hung up on what it is called. If what is occurring is servers or bartenders are giving money to the back of the house or management per a mandatory system, it's a problem under the federal rules, regardless of what you call it. Okay?
Okay, so I'm going to briefly try again to take everyone off mute and allow some people to ask verbal questions. If you hear that you're getting a lot of reverb on your line, please mute yourself. And so we'll give this a go, and hopefully it will work out at least partially.
And I did see a question in the chat. Exactly how is an employer supposed to monitor reporting of tips when they have no idea what they are getting? Great question. If, for example, your guests are primarily leaving tips on credit cards, that's a good way to look. Compare tips left on credit cards to tips left, tips declared. If you are a primarily cash establishment, then you still kind of know tipping customs at your establishment, or what people are doing typically in the industry and in your establishment. So if bartenders are declaring $0 or they're declaring $5, then either they're under declaring or they're really, really bad at their job. And either way, they probably shouldn't be working for you. So those are just a couple of observations and options.
Okay.
Any other questions?
So I'm going to unmute everyone now, and we'll give it a go.
Unmuted.
Okay. Anyone with questions they'd like to voice over the phone to Bob, you're on the air.
While people are thinking of a question, let me just throw one out there. We talk about this in terms of front of house, back of the house. But understand it can come up in other areas, right? Let's say you do a lot of delivery service and your drivers keep the tips. And you require your drivers to share those tips with folks who bag the food and with the kitchen guys and with people who were behind the scenes. That's going to be very narrowly viewed. If you're sharing it with the people who took the order over the phone and things of that nature, that's better. But I would recommend against making the driver share the tips with the employees who are bagging the food and things of that nature, assuming they're not engaging in any direct customer interaction for those deliveries.
No, we're getting a lot of feedback off of phones, and it doesn't seem to me like we have a lot of other questions coming in. So I think we're going to wrap up the webinar as of right now. They've got your contact information, Bob, your phone number. We've had a lot of great questions today. All of this information will be available online afterwards as well.
And where will this be available? What website?
This will be available on the Washington Restaurant Association website. If you
Can I ask one?
Is there someone still there?
Yes.
You have a question for Bob?
I do, but I don't know if Bob, are you able to hear me?
I can, yep. Hello.
Okay. Hi. Currently, we have a system where the servers aren't completely in charge of their gratuities, and then they are encouraged by the owners and management to tip out the kitchen a percentage of their take-home gratuity. Are we somewhat compliant, not compliant at all? Are we on the right track?
Yeah, unfortunately, these things come down to either compliant or not compliant. Nothing in between, unfortunately.
Sure.
And so if they're encouraged to do it, but again, let's say on any given night, some tip out 0 and others tip out below the recommended encouraged amount, others go higher, and it's really across the board, then I'd say, to me, that looks like a voluntary one. But I would still recommend maybe some written communications to your team about, look, it's voluntary, this, that, the other, so that you can point to not only, hey, in practice, everyone's doing their own thing, but even for those who are tipping out precisely 3% every single night, they were told, hey, it's voluntary. You don't have to be doing it that way, kind of a deal. So I hope that answers your question.
Somewhat. So we would be best protected as if we put something in policy as it's strongly encouraged or careful wording in that regard.
Careful wording. I would not say strongly encouraged. I would
Okay.
move away from recommended or encouraged.
Okay.
I've worked with employers a lot on what the language should look like, but but it also is relevant getting the employer's feedback, and saying, well, I don't like this language, but how about that? Sure.
Okay.
But yeah, I would move away from encouraged, strongly encouraged, recommended.
Okay. And your contact info will be on the WRA website?
Yes, it will be. We'll make this presentation and his contact info available to you.
Wonderful. Okay, thank you so much.
My pleasure.
Can I ask?
And also, yeah, sure.
So I feel like you've kind of already gone through this, but I want to just specify. So most of our bars are very, very small. So we tend to have, 1, maybe 2 bartenders on, and then a manager who's also bartending. and it is a complete tip pool. It always has been. They don't even ring individual items up under their names. It's all under the bartender. And then at the end of the night, they divide the tips by hours worked. Is that compliant? And again, in that one ways is a mandate.
I would, in that model, I would not have the bartender receiving any of that tip pool. This is different. This is different than the scenario where the manager is out acting as a server and picking tips up off of those tables in that manager's section. But it's all being pooled, and then they're all. I would not do it. That's my short and sweet answer. Okay.
Yep. Thank you.
Yep.
Okay. Well, I think that probably does it for now. Thank you so much, Bob, for all of your input and all of your great answers to these questions. You've been a big help for us all here and our members. So once again, I'll put all of this information up on the website. And if you have any further questions, please see the last slide where Bob has his number and email address listed. Thanks, everyone.
And also, just so everyone knows, I am offering a reduced rate to consult on these issues. My goal is to be accessible to everyone and for my pricing to not be an impediment. So I am offering a half-hour consultation on this issue for a very reduced rate. So, okay.
Fantastic. Thank you.
Thank you all.